Welcome everyone to the Brownfield Braintrust. Welcome everyone to the Brownfield Braintrust Podcast. For those of you who don't know, a brownfield is a property, the expansion, redevelopment, or reuse of which is complicated by the presence or potential presence of a hazardous substance, pollutant, or contaminant. Most people think there are well over 500,000 brownfield properties in the U.S. These properties can be gas stations, dry cleaners, plating shops, refineries, tank farms, or anything industrial manufacturing that you can think of. A brownfield is incredibly difficult to remediate, and buyers cannot typically find debt to acquire them. So this Brownfield Braintrust Podcast, say that 10 times, is a forum to discuss some of the vexing problems that may be associated with transforming environmentally blighted sites into beneficial uses. We will tackle some of the regulatory, financial, and technical nuances. We always get great speakers, and today we have an esteemed attorney with us, so of course there will be a disclaimer. So the disclaimer today is that the purpose of this podcast is to provide information on current topics of general interest, and nothing here shall be construed to create, offer, or memorialize the existence of an attorney-client relationship. The content should not be construed as considered legal advice or opinion because it may not apply to the specific facts of a particular matter. As guidance in areas is consistently changing and evolving, you should consider checking for updated guidance or consult with legal counsel before making any decisions. The opinions expressed during this podcast are the opinions of the individual only and do not reflect the opinions or position of Snell and Wilmer or any of its individual attorneys. That being said, let me tell you a little bit more about what we're going to discuss today. Today, we have an esteemed environmental attorney, Sean Sherlock, who will answer questions pertaining to environmental justice as it relates to brownfield redevelopments. We will touch on one, how EJ matters, environmental justice EJ, well-intentioned as they may be, can thwart brownfield investments, and secondly, new EJ laws that are now being promulgated. Let me tell you a little bit about our guest. Sean Sherlock is a partner at the law firm Snell Wilmer. He represents real estate developers, investors, and lenders in environmental, land use, eminent domain, and real estate litigation matters. He litigates cases under the California Environmental Quality Act, I think we've all heard of CEQA, and advises clients preparing environmental impact reports, EIRs, and other CEQA documents needed to obtain project approvals. Sean has extensive experience representing clients in environmental cases involving contaminated properties, air and water quality, and government enforcement actions. He also represents clients in eminent domain and a variety of real estate and business litigation, including contract disputes, commercial landlord-tenant disputes, and loan enforcement. Now, Sean's education and early professional experience as a chemical engineer and environmental specialist for Chevron. By the way, I was an environmental specialist for Chevron in the late 80s as well, small world. But that gives Sean a unique industry perspective and understanding of the issues businesses face. Welcome, Sean. We're going to have some fun discussing a critical topic that not too many people are aware of. In the context of brownfield development, what is environmental justice, or as everyone refers to as EJ?
Yeah, hey, Matt. Great to be talking to you about this today. In terms of what is environmental justice, environmental justice has been around, the concept has been around for quite a long time, really going back to the 1980s, early 80s. And in general, it reflects a concern that our industrial development and the consequences of it, industrial pollution, should not really be borne, or the brunt of that should not really be borne by minority communities, low-income communities, and so forth. Now, both the federal government and California have a definition for environmental justice, and the two definitions are very similar. I'll just try to give you the gist of both of them together. Both definitions reflect that environmental justice has two components to it, a substantive component and a procedural component. So substantively, environmental justice is about fair treatment, and procedurally, it's about inclusion and meaningful involvement of all people, regardless of their race, color, national origin, or income. And it is about that in the development, implementation, and enforcement of our environmental laws, regulations, and policies. So again, substantively, environmental justice is about fair treatment, procedurally about inclusion and meaningful involvement of all people, regardless of race, color, national origin, when we develop our environmental laws, policies, and so forth.
I think that the environmental justice, as most people perceive it, or most people hear it, has to do with, for instance, manufacturing industries close to residential facilities. Isn't that where most press seems to focus on?
Well, So historically, I think that's right. That was generally the concern, locating hazardous waste treatment facilities or disposal sites, landfills, or chemical oil plants, what have you,
yes.
Near residential communities. The idea was that, if we're going to locate this hazardous facility, we shouldn't be putting it preferentially near a minority or a low-income community. I mean, because for obvious reasons. Mm-hmm. But it really is more than that at this point. It's expanded to lots of different facilities, including even any sort of industrial facility, any facility like a gas station. I mean, lots of different, and as we will discuss, it's going to have some application in brownfield redevelopment as well. So I think it could and will be applied in brownfield redevelopment situations in a number of different ways. First, public participation in the community. So whenever someone's got a brownfield redevelopment project and it's in or around one of these environmental justice communities, or what the government sometimes calls disadvantaged communities, there are going to be heightened public participation requirements associated with the approval process for this brownfield redevelopment project. And I think you're also going to be seeing more stringent health and safety standards, more intense oversight, and possibly more enforcement during the remediation process for the brownfield. And then finally, likely more stringent cleanup standards are going to be applied at this, because if there's not, invariably the developer is going to be facing claims from project opponents that, hey, you're doing this, you're trying to clean up this hazardous waste site in an environmental justice community, and you're cutting corners. That'll be the claim. You need to apply more stringent health and safety standards during the remediation, so the community's not exposed to contaminants and so forth. And you need to make sure that this site is cleaned up as stringently as you would require, any other site in any other place to be cleaned up.
I understand, and thank you for that broad perspective. With respect to what's guiding EJ now, are there any laws or guidance that currently exist?
Yeah, there are some on the federal level and some on the California level as well. Federally, environmental justice is really kind of guided, or at least to this point, let me say, because especially this year, there's a lot of news, a lot of developments on the environmental justice front on the federal level. But to this point, environmental justice at the federal level has really been guided by Title VI of the Civil Rights Act of 1964. Section 601 of Title VI essentially provides that no person in the United States shall, on the ground of race, color, or national origin, be essentially discriminated against under any program or activity receiving federal financial assistance. And so, to the extent, again, if we look at this in the context of brownfield redevelopment project, to the extent that a brownfield redevelopment project is getting any sort of assistance, financial assistance from the federal government, then that project, the developer is, and or the city or county, the municipality that's sponsoring the project, is going to, be subject to Title VI of the the Civil Rights Act. And that allows two forms of enforcement, or two ways in which project opponents might try to enforce environmental justice concerns there. Number one, through a lawsuit in federal district court, or number two, through an administrative complaint with the EPA. Now, to this point, lawsuits in federal court have not been particularly successful because there have been some cases, U.S. Supreme Court cases, Guardians Association versus the Civil Service Commission, a 1983 case, essentially held that to prevail in that kind of a lawsuit, you've got to show intentional discrimination, that the municipality or the entity receiving the federal financial assistance was intentionally trying to discriminate against people on the basis of race, color, national origin. That narrowed the field quite a bit as far as complaints that could be successfully prosecuted in federal court. And then another U.S. Supreme Court decision, Alexander versus Sandoval, 2001, essentially ruled that disparate impact, that there was no private right of action to try to enforce a disparate impact claim. Disparate impact being one in which the discrimination is not intentional, it has a valid, neutral purpose to it, but nevertheless has disproportionate adverse impact on people based on their race, color, national origin. So as a result of that, more and more of these environmental justice complaints at the federal level have been prosecuted through administrative complaints with the EPA rather than lawsuits in federal court.
When these lawsuits are brought, what are the goals of those bringing the suits? Are they trying to enact more stringent cleanup standards? Are they trying to get people to stop building their manufacturing facilities as close as they are to residential facilities? What are the end goals typically?
Well, the end goal is typically, I think to stop the project, right? We don't want this. Whatever it may be, landfill, industrial facility, located here. And so we want the permit to be revoked.
I see.
And we want an injunction to enjoin the project from going forward, generally speaking, that's the objective.
And so you've talked about some of these federal laws. Are there some state laws or guidance that exist that currently?
Sure. I would also mention, just before we move on to state,
sure.
If I could back up a step.
Of course.
Also at the federal level, in addition to Title VI of the Civil Rights Act, earlier this year, President Biden issued an executive order addressing environmental justice. It's Executive Order 14,008. And he sort of outlined his environmental justice strategy, which has really four main components to it. And I think this is very insightful because it gives us some idea of how, at least in the next 4 years, how the federal government is going to be approaching environmental justice. First strategy is to strengthen enforcement of violations in what the president calls underserved communities, environmental justice communities. And so businesses operating in those communities and or developers who want to develop a project in those communities should expect that there's going to be more agency inspections and greater enforcement and potentially more severe penalties for any sort of environmental violations in those communities. Second strategy is community notification and real-time public monitoring of facilities. So the president is calling for effectively, web-based data reporting real-time by operating facilities in those environmental justice communities so that the public can monitor pollution from these facilities and act on it. Thirdly, the president is calling for the Attorney General to create an environmental justice enforcement strategy. And then fourth is his Justice 40 or the Justice 40 initiative. Justice 40 initiative is one promoting 40% of the benefits from federal investment to disadvantaged communities. And these are federal investments in clean energy and energy efficiency projects, clean transit projects, affordable, sustainable housing projects, workforce development, and notably, Matt, of interest to you, remediation of legacy pollution.
Oh, goodness.
As well as clean water infrastructure. So one of the opportunities, if you want to call it that, are coming out of these environmental justice initiatives, is that there probably is going to be more federal money to clean up contaminated sites within environmental justice communities.
Well, that's good to know, because there hasn't been much funding available the past 4 to 6 years.
So then moving on, getting back to your question about this at the state level in California. California addresses environmental justice primarily through municipal general plans. So under state law, counties and cities are required to adopt a general plan, and that general plan has to cover a whole range of different municipal planning priorities, including principally zoning, land use, all that kind of stuff. But each general plan under a law called SB 1000 was passed in 2016. Every municipal general plan is required to have an environmental justice element to it. This is going to have to be included or added to a city or county's general plan with its next major general plan amendment. To this point, a lot of cities and counties haven't yet done their next major amendment, so they haven't. Some have, many haven't, but those who haven't are very soon going to be adding environmental justice elements to their general plan. And under the law, the municipalities are going to be required in their environmental justice element to, number one, identify what they call disadvantaged communities. These are essentially low-income areas that the state believes to be disproportionately affected by pollution. Number two, the municipality is going to have to identify objectives and policies to reduce unique or compounded health risks in these disadvantaged communities. And that could be done by, for example, reducing pollution exposure there, improving air quality there, promoting public facilities there, even things like promoting food access in these communities is considered to be a tool to promote environmental justice. Anyway, and there are a number of other ways in which the state believes you can promote environmental justice in these communities through the general plan, like safe and sanitary homes, promotion of physical activity, and promotion of civil engagement in the public decision-making process, and so forth. So that's what's going on in California as far as environmental justice, or at least that's the existing environmental justice legal framework.
I was going to say, and I know there's more. There's more coming around the bend.
Yes, there's more coming around the bend. We'll see whether it comes around the bend or not depends on whether or not these bills, pass through the legislative process and get signed by the president or the governor, as the case may be. But so in the federal system, there are a number of environmental justice bills that have been introduced in Congress this year. I think most notably is the Environmental Justice for All Act. This is HR 2021. And the Environmental Justice for All Act would effectively reverse those Supreme Court cases I was mentioning earlier, and by allowing a private right of action in federal court on a disparate impact claim. That's really going to open up environmental justice claims in federal court, and sort of turn the situation around. This particular bill, or at least the purpose of the bill here, has been around for a while. It's been introduced in Congress over the last couple of sessions at least, and just hasn't passed, but has a better opportunity to pass in this session of Congress. The Environmental Justice for All Act does some other things as well. I mean, it does many, many other things. It's well over a 100-page bill, provides funding for environmental justice groups and environmental justice projects, and it would require denial of Clean Water Act and Clean Air Act permits if based on potential cumulative impacts. If potential cumulative impacts of a project are going to have some disproportionately adverse effect on environmental justice communities, then this law would require permits to be denied, which could be significant, obviously. Then it could hinder, development. Now, some would say, well, that's development we don't want if it's going to disproportionately adversely affect the environmental justice communities. But who knows how that'll all shake out. There's also another bill that I get a kick out of called the Environmental Justice for Coronavirus Affected Communities Act.
Oh my!
Yeah,
haven't we all been affected?
Well, that's a good question, Matt. I paid fairly close attention to the coronavirus stats for the last year, and I would say we've all been affected. But I guess the thought is if you add the term environmental justice and coronavirus to the name of your bill, it will probably pass and get signed by the president.
I see.
But really, the Environmental Justice for Coronavirus Affected Communities Act is pretty much just a money giveaway, I would say. It's really just funding for, primarily for environmental justice small grant program, but it's $50 million to fund this, it's $50 million to fund something else, and $50 million to fund something else. So not the sort of thing that's going to have a direct, impact on development, maybe an indirect impact. We'll see. And then there's also the Environmental Justice Mapping and Data Collection Act, HR 516, which is introduced in Congress. That bill essentially just establishes a new committee, the Environmental Justice Mapping Committee, and requires the committee to develop an environmental justice mapping tool. I'm a little bit perplexed about this because the EPA already has an environmental justice mapping tool. It's called EJ Screen, and it's a very handy little tool, a very interactive tool. If you just Google EJ Screen, it'll come right up, and you can focus in on whatever community or region within the United States that you want to look at, and it will give you all kinds of demographic and environmental data for that region. Interesting tool, but. And anyway, so those are the laws being proposed at the federal level currently. Then in California, we've got a bill, AB 1001. As introduced, it was a pretty heavy lift. It would have really made any kind of a development of environmentally related facilities within disadvantaged communities, or what the state of California calls disadvantaged communities. It would have made it very difficult. Would have required a 60-day notice of an application for any environmental permit, which fine, fair enough. It would have required the applicant to prepare a new document called an environmental justice impact statement. Would have required a public hearing in the disadvantaged community. But then also would have required that no permit could be issued until 45 days after that public hearing. And most significantly, it would have required denial of any environmental permit on a finding of an adverse cumulative or public health stressors higher than those borne by other communities in the state. And so, as you can appreciate, that's
nebulous.
That's a pretty nebulous standard. Certainly subject to lots of interpretation. Reasonable minds could differ about that, and certainly plenty of lawsuits could carry on for years, litigating whether or not that is the case in any given on any given permit application. Now, I tell you that the bill has since been amended and really amended fairly heavily. Most of what I just told you is now out of the bill, and it's been amended to require that any mitigation of environmental impacts of projects within disadvantaged communities be implemented within the affected disadvantaged community, which strikes me as fairly reasonable. But the point being, for example, if a project needs to mitigate its greenhouse gas emissions, that those mitigation need to be done in the community. You can't just plant 1,000 trees in the Philippines somewhere to mitigate your greenhouse gas emissions in, Cerritos, for example.
I understand. Now, from what I'm understanding, these California rules that are being considered relate to facilities that have environmental emissions, whether they be via air or storm drain or sewer. We're not talking about housing developments, are we?
No, not really.
What about a strip mall? I'm trying to get a feel for the types of facilities that this law is really going to impact.
So the AB 1001 would impact any project that requires an environmental permit. And so primarily a lot of these would environmental permits defined to be for example, hazardous waste permit, other types of permits that most developments are not going to need, but also includes air permit from the AQMB or waste discharge requirements from the regional board.
I understand.
And so air permit opens it up a little bit. Lots of commercial facilities require air permits.
Absolutely. There'll be a de minimis permitting threshold that will not yield environmental justice reviews. If it's just a small boiler, may have a certain exemption on versus a large industrial boiler.
Sure.
Who knows? I'm speculating.
Yeah, it was not written that way. But as it's been amended, again, it really that's all been taken out.
Oh, I see.
Yeah. And so as it's been amended now, all that's required is that as the project goes through the CEQA process. So really, the facilities or developments that would be affected by this law currently would just be any project that requires CEQA review.
That incredibly popular review.
Sure, that's a pretty broad scope of projects, right?
Yes, it is.
Yeah.
Now, okay, so these laws mostly are those that fall under CEQA, mostly thinking that need environmental permits, air, water, stormwater, wastewater. What about those developers such as myself and many of the people who could be listening here who are taking blighted, contaminated properties, and maybe they're going to do some major tenant improvements, or they're going to knock down buildings and put in multifamily dwellings, or maybe it's a vacant land that they're going to put in a commercial strip center. But they have some toxins to remove. They've already got very stringent laws and guidance documents telling them how they should remove the contaminants. How will environmental justice laws that are being promulgated, or even in the books now, impact these brownfield developers?
Well, I would think in a few ways. First, you're going to be seeing much higher scrutiny when you have a brownfields project in an environmental justice community, again, or in what the state calls a disadvantaged community, which are communities, there's a whole host of considerations that go into whether or not a community is a disadvantaged community. It's primarily related to income levels, poverty rates in the community, educational attainment in the community, and a number of other different factors. But when you are doing a brownfield project let me just say, if you want to find out whether or not your site is in one of these communities, there's a handy tool called Cal EnviroScreen. And again, you just Google Cal EnviroScreen, and just like EJ Screen, it's a very interactive, user-friendly tool where you can zoom in on any community within California, and it's a colored map. And it's colored from dark green to light green to yellow to orange to red. And if you're in a red zone, you're in an environmental justice community, that's or even an orange zone. I mean, the interpretation is not entirely well defined, but the orange and red zones are areas that are more sensitive to all of the environmental stressors and demographic factors and everything else that go into California's assessment of disadvantaged communities.
Well, I'm writing that down. It's going to be part of my screening for projects I look at. And I will confess, if I'm now doing a project in Pacific Palisades versus South LA, I know I'm going to get different scrutiny. And what this EJ, and it's voluntary scrutiny on the part of folks in the Palisades who have incredible resources and will bring lawyers to the table and their own environmental consultants to review what I'm doing. That's not necessarily going to happen in South LA, but it sounds like these EJ laws and guidance are going to prompt some more scrutiny for my projects.
Yeah, I think so. I mean, like you're suggesting, historically, if you were going to compare projects in those two areas, the concern is that you'd get a lot of scrutiny and pushback if you wanted to develop something in Pacific Palisades and not much in South LA. And that's not right. The people in South LA have every right to have their health and safety and well-being taken into consideration as people in Pacific Palisade who will push back vigorously. But
absolutely. But I must mention something with respect to Winefield Associates. We take great pride in taking blighted sites in disadvantaged communities and bringing them to beneficial use. It's what I wake up and enjoy doing. And I welcome a lot of these EJ oversights because frankly, some of my competitors are not as thorough as we are, and I'll leave it at that. Since my podcast, I get to say that.
Yeah, well, I mean, I think that's exactly right. If there is a way to navigate all of this, and and look, yes, communities that have been traditionally underserved, they deserve good facilities, good, nice, livable communities, and all of the amenities that other communities have. So they need redevelopment, and that's great.
So I think some folks, go ahead, sorry.
Go ahead, Matt.
Well, I think some folks who always oppose brownfield development, no matter how much benefit these projects will bring to the community, could conceivably use these EJ initiatives to thwart projects. How might folks do that?
Yeah, so it's not uncommon, obviously, in California. No matter what your project is, no matter where you're going to build it, there's going to be someone who doesn't want that project in that area or on that location. And there are already a number of means to try to stop that. And with using environmental justice, there are really a few ways to do it currently. One, as I mentioned, would be action under the Federal Civil Rights Act, Title VI of the Civil Rights Act. Number two would be NEPA, the National Environmental Policy Act. If the project requires any kind of federal permitting, then NEPA may apply. And under NEPA, there are guidelines that require environmental justice concerns to be taken into account. And if they're not, that could give rise to a potential action under NEPA based on or grounded on environmental justice issues. And then under the state, under state law, CEQA, California Environmental Quality Act. Now, currently, California Environmental Quality Act really only governs physical environmental impacts or physical impacts on the environment, and social issues are not something that can be raised in a CEQA lawsuit. But one of the factors that you have to consider in a CEQA analysis is whether or not the project is inconsistent with or conflicts in any way with the city's or the county's general plan. And soon enough, every city and county is going to have an environmental justice element in its general plan. And so there will have to be some analysis as to whether or not the project is consistent with the environmental justice element of the city or county's general plan. And that will be a way for project opponents to raise environmental justice concerns under CEQA.
For these general plans, are there certain municipalities that are ahead of the pack that have EJ criteria that folks can look at just to get a feel for what these look like?
Well, I can tell you, yes, there are, but which ones, I don't know. I couldn't name off, which cities have already adopted their environmental justice elements.
So developers have a lot of challenges when they want to build a multifamily complex, affordable housing, retail, industrial, whatnot. So what can a real estate developer, brownfield developer, or just an investor do to anticipate and address some EJ issues now?
Yeah, so first I would say identify the EJ issues in your community, right? And like I say, there are a couple of tools where you can do a little digging and figure out what the environmental justice concerns are, if any, in that community. Secondly, I would say engaging with the community is very important because under all of these environmental justice initiatives, again, one of the things they really require is inclusion and meaningful participation by everyone in the community. And with all of the environmental justice grants and everything else, I mean, more and more environmental justice action groups or community groups, 501c3s are forming, are organizing, and they are showing up at hearings for everything, for permits, for rulemakings, for everything. And so it's important really to get out in front of them, engage with the community, identify people in the community who, will support your project. Because ultimately there are going to be some who won't support it, and they're going to show up at the city council hearing. So you want to definitely try to rally as much support for the project as you can get, and also hear all of the concerns. Do what you can to address all of the concerns, quite obviously. And then I would say finally mitigate. Address whatever the community's environmental justice needs are. Again, some communities have different environmental justice needs. It may be, well, we have a lot of, toxic waste sites in this community, or whatever. Our drinking water, is not as good, or our air quality here is particularly bad, or we have problems with, food availability or recreational opportunities, all kinds of different things. Once you identify what those needs are, focus your mitigation on those needs.
It's certainly critical. I will say that in my experience redeveloping sites for brownfield sites and bringing them back to beneficial use, we have rarely received any negative feedback. Folks are happy to get rid of a toxic dump and bring something that the community can use. And so we have it easy. When something is horrific to begin with, everything is going to be an improvement. And obviously we enjoy reaching out to various communities we work in, but this is going to prompt everyone to reach out to the communities they work in, which is a good thing.
Yeah, it sounds like you've done a very good job navigating it. And
do you like the way I break my wrist, pat myself on the back?
Very nice, very nice. Yeah, well done. You've sold me.
Well, do you think that when all is said and done, these EJ rules are going to reduce development in California, and more importantly, housing development in California? Are developers just going to go elsewhere because this is just another arrow in the quiver that can bring their projects down?
Yeah, that is a very good question. I think a lot of that remains to be seen. I think there should definitely be a concern about unintended consequences. Very well-intentioned programs here, but what if they end up just chasing away private investment from, the red zone, orange zone environmental justice communities? That strikes me. That would be a concern that I would have. I think ultimately, developers are going to weigh, advantages, the pros and the cons of developing a project in an environmental justice community, right? And there can be many pros that have nothing to do with these issues. One of the pros under the environmental justice initiatives may be availability of federal or state funding or support or assistance in some other way. That's going to be available to help revitalize EJ communities. Disincentives, of course, you can expect, more tools that will be available for any opposition to the project. You're going to have heightened government enforcement and scrutiny and the project, and down the road for operations. Right? It's not just developers who are affected by this. It's the people who have facilities that are operating on a day-to-day basis in these communities who are also going to be under the heightened scrutiny and enforcement. So, again, whether this chases anyone away, who knows? Presumably, it will discourage some and not others.
Well, also, I didn't realize what a heavy federal EJ program is about to exist. So whereas with some other rules, developers and other business folks say, I'll just leave California, it doesn't sound like it's going to get much easier in other states.
Well, a lot of that depends on exactly what happens at the federal level,
Is California further along than many other states?
Yes.
Okay.
Yeah, sure. I can't tell you what all 50 states are doing, and are there some states that are further along than California? Maybe, not to my knowledge, but that may very well be. California is certainly further along than the federal government, in as much as we actually have a law on the books that's going to require the implementation of these EJ elements in the general plans. But whether or not the federal government program becomes as robust as what California has really depends on what happens in Congress with that Environmental Justice for All Act in particular.
Mm-hmm. Well, we've heard a lot of information, and is there anything you think we've missed for the sake of an introductory podcast on EJ?
I don't know. I think we've covered it, Matt.
We're pretty darn thorough, aren't we?
Yeah, very good.
And I would suggest anybody who has more questions to not contact me, contact Sean Sherlock. You want to share your email address with the team?
Sure. My email address is my first initial and last name. So that's S Sherlock, or SSHERLOCK at SWLAW.com.
Well, this has been fun. I enjoyed podcasting with you, sir. Podcasting is the communication tool of this era, is it not? And I don't drive without one. I don't drive without one.
I don't drive without one. I don't shave without one. I love podcasts, Matt, and thank you very much for inviting me on. This has been fun chatting with you.
It's been a privilege having you. Have a great year.
All right, you too. Take care.
And we're back. So we said our tearful goodbyes, and we realized we forgot to talk about a very critical environmental justice matter, and very local. So all you brownfield developers, Sean has one more thing to say.
Yeah, so there is another, I think, very significant brownfield or environmental justice development afloat, which is in LA County, the proposed LA County Green Zone Ordinance, which is up for consideration and probable adoption later this year, probably in the fall of 2021. The Green Zone Ordinance, effectively, it's very lengthy, very complicated. For sure, it's 161 pages presently. But essentially what it does is the county is going to designate 11 green zone districts. These are environmental justice communities within unincorporated areas of LA County, mostly in the eastern and southern areas of LA County. And in those green zone districts, they are essentially applying heightened operating restrictions and development standards. So if you have a project that you want to develop in one of these green zone districts, you're going to be facing heightened development standards there. If you are an existing business or industrial operation in those green zone districts, you're going to be facing heightened scrutiny and so forth. There are a number of other provisions to this green zone ordinance other than the green zone districts. They mostly seem to be focused on waste handling businesses as opposed to development. Scrap yards, landfills, solid waste processing facilities, recycling, sorting, and processing facilities, green waste processing facilities, and so forth. Those seem, any kind of auto-related facility those seem to be the target of the green zone ordinance.
So everyone look out for the green zone ordinance. Is it about to be released or has it already been released?
There's draft. It's out for comment. They keep pushing back the date. They were hoping to, I think, take it to the Board of Supervisors next in June of 2021. That seems to be getting pushed back now to October of 2021.
So Brownfield Braintrust Podcast listeners, you heard it here first. Look out for green zones. Thank you again, Sean.
All right, Matt. Great talking to you.